Good evening to you, my co-host, Mr. Leonard Gildari. How are you tonight, sir?
Pretty good, pretty good. And there's some other news is coming out now with regards to more
I know.
sanction. Apparently, there's going to be more revokees in Guyana. So good
Correct.
night to you, Yog.
Correct. Thank you. Correct. Indeed, ladies and gentlemen, as we speak, we have received information, confirmed information, that is, that Michael Kozak, would have made a release today and citing specifically the Granger administration. I want to hand you over to my co-host, senior journalist, Mr. Leonard Gildari, to share that news with you. But at the top of this program tonight, we recognize that the U.S. continues to stand by the side of the people and calling on the Guyanese, the Granger government, Granger administration to recognize the will of the Guyanese voters. Leonard?
Yes, thank you very much. And this is Michael Kozak, and this is the American Assistant Secretary of State. And during a press briefing today, I'm just going to read you what it is, the breakdown or the interview as it was would have on roll itself, and this is what it says. And thank you for all joining this call. I hope you're all staying safe and strong. Want to take a step back and look at one of the key policy priorities, which is advancing democracy in the Western Hemisphere, the hemisphere of freedom. Today, the vast majority of countries in the Americas and Caribbean our democracies. We're getting ever closer to the ideal that OAS member states committed to when they signed the Inter-American Democratic Charter in 2001. We've been working with our partners and through the OAS to stand up for democracy where it's on the threat, and at the same time, we're trying to turn the tide in those countries where democracy is but a dream. On July the 15th, the Secretary, and this would have been Mike Pompeo, announced the imposition of visa restriction on individuals responsible for or complicit in undermining democracy in Guyana. Today, we are acting to prevent additional senior individuals from that country from entering the U.S. So this is additional. The secretary has been very clear. The Granger administration and its allies continue to defy the will of the Guyanese people by refusing to accept the vote count. The count has been certified as valid by international observers, OAS and CARICOM. Guyana's and Caribbean's highest courts. The United States joined the rest of the region, refusing to go along with this farce. We will continue to act until the Granger administration accepts the will of the Guyanese voters. We welcome the renewed partnership between the United States and Bolivia. There's another one. But that in essence what it is. So they call it farce, very strong language as we go down there. Yog. So it would come hours after we would have had that delivery of decision by the Court of Appeal. Over to you,
Right.
Yog Mahadio.
Thank you, and thank you for that top of the hour news, Leonard, with regard to the U.S. announcing that it is having an even sterner, stronger look as to what it can do with the individual sanctions that can be placed upon persons in Guyana linked to the Granger administration. Ladies and gentlemen, you would recall that a couple of weeks ago we shared information with you that our information was that the top members of the Granger government has already been restricted in terms of what they could do. And also, based on the news we have gotten, it has not only been restricted to the Granger government per se, but also persons who were seen to be aiding and assisting this thwarting of the will of the electorate. Ladies and gentlemen, I want to also share with you, Leonard, as we are joined by our two guests, let me share with you all that Guyana is already being referred to in international circles in very negative light. In fact, one of the questions to Michael Kozak today, Leonard, was that what message do you think that the president's floating the idea of delaying November election sends to U.S. neighbors in Latin America, like Guyana and Bolivia, right? So Guyana has been singled out, which means that a lot of persons in the press corps there are aware also of what is happening here in Guyana. And last night we heard Sir Ron Saunders we did speak to the possibility of economic sanctions coming down sooner, or well, hopefully not. But if this thing continues, then it is one of the other things that can happen. So, ladies and gentlemen, as we get into our discussion tonight, let me take this opportunity to once again welcome you all joining Room 592 from wherever you have joined us tonight, all across the country, Caribbean, Brazil, of course, Suriname, and elsewhere, US, Canada, all across the world. Welcome to Room 592, where we unleash the truth. And let me say a special welcome to Senior Counsel, Mr. Anthony Astaphan, joining us all across, from way across the Caribbean. Sir, welcome to you, and a warm good night to your director and the person in charge of your life there, sir. Please give her our warm regards tonight as well, sir. Welcome.
Thank you very much. Because I was getting directions from my director, I was late to join you today.
Great. And let me also welcome almost Senior Counsel, Mr. Sanjeev Datadin. Mr. Datadin, welcome to our Room 592, sir. And I know you're on the phone, so let me allow you to finish your conversation. And
no, sorry, Yog. Somebody was just checking into me. Good night to you, Yog. Good night to, of course, Leonard. And Senior Counsel, always my pleasure. Good night to your listeners. Good night to my beautiful wife. Hopefully, today was interesting.
Great, indeed.
A lot to get to.
Let's get on with the discussion. Ladies and gentlemen, you all know today was 3-0. Unanimous decision at the Court of Appeal to dismiss that appeal. Majority decision to get a 24-hour stay, of which maybe 6 to 7 hours have already expired, or at least 4 or 5 hours have already expired. But ladies and gentlemen, more than that is the fact that now GCOM will be meeting on Sunday. So, Mr. Datadin, sir, I want to bring you in first. What has the court given a stay on? I remember that was a lingering question. You have given a 24-hour stay on what? Because your decision is already delivered. What is it? And notwithstanding that, counsel, GCOM has given the good counsel 3 days for them to decide what they want to do next.
Yep.
Well, I think if you look at it, Yog, the long and short of it is this, and I know Senior Counsel will go to tongue about what happens with getting a stay. There are 3 things that I would like to say about it. The first thing is, unless the court makes an order that directs what we would term a coercive order, that you shall do or not do refrain from doing something, or you shall pay or do any act like that, I can't understand how a stay would apply. That's the first thing. And there is indeed nothing here to stay. So the grant of a stay is really perhaps something for the masses to consume, to say, well, oh, the decision is stayed and what else is going on. So I don't believe there's anything to stay. That's the first thing. The second thing, Yog, is this. For you to be granted a stay, there are usually certain preconditions that are required, and there are certain things that must be satisfied before that happens. Granting a stay is not an as of right matter, and those of us who practice in the courts will know that going to the Court of Appeal for a stay is not an easy thing. It's not a given. You've seen lawyers complaining on Facebook that they have had cases where even if the merits are very good and the stay has not been granted by the same Court of Appeal. And you're considering that from the point of view where the court has unanimously ruled against this appeal and said it was frivolous and vexatious and res judicata. That's exactly what the High Court said in the same sort of things. And the third thing is there is no appeal in being. This has to you have to get leave to appeal first. And there is no application yet to the Caribbean Court of Justice. Now, we know that in David, which was what they were trying to say, what Mr. Ford was trying to refer to, but in David, as Anthony will tell you, that in David, the CCJ itself, upon the special leave application being filed, that court made an order that all parties hold their hand until the appeal is done. That was a positive order. So to answer you as to what has been stayed, I can't say that there was anything in the order that required a stay or that can be stayed. That's the first thing. The second thing, I thought that the court decided and then changed its mind, which is a little unusual, but that's the way it is. As relates to the 2 days, the GCOM is not meeting until Sunday. I know that it is not a pleasing thing. My personal view is that GCOM should get on with the work. We need it to move forward. But you can take the view that, it is the view of some people. I'm not saying agreeable or disagreeable, but it appears to be the view of the chairman that tomorrow is a Muslim holiday in Guyana. It's a national holiday. And the day after is Emancipation Day in Guyana. And she is perhaps taking the view that there are 2 holidays that are coming. That being the case, in the time of elections and in election matters, none of these things ever mattered before. Sunday could fall on Thursday during the election. The way it is, it would never matter. But I guess in Guyana having waited for so long, and it has gone around in such a circle for so long, that it is now almost considered to be part of the way we deal with things usually.
Right.
And we're saying, well, these are not working days, so the next working day we would push to be a Sunday. So, I mean, whatever it is,
Right.
I can't say that I'm wholly in agreement with it, but I can't say I don't understand what has been said in relation to why Sunday. I understand, not necessarily I agree.
Got you. Well, thank you for that, Counsel. Senior, I want to come to you. Today in court, the following words came out. This appeal is frivolous and vexatious and amounts to a further abuse of the court. And in case of all 3 judges, Senior, they all recognize that this matter, by and large, was res judicata. Your comments, sir. When lawyers go to a court on matters that are largely decided already, stare decisis as well, isn't it a concern to the court as well, sir, that such things would keep coming up and coming and on and on? Is there something that stopped, or is there anything that could stop such floodgates from continuing, floodgate approach?
Yes, yeah, there are things that can stop it. One of them is the court. And the words the Court of Appeal used, I watched some of it today. Not all. I couldn't watch all because I have court tomorrow. The body language of the judges when they were reading their judgments, I got the impression that they've had enough of this. And the language of res judicata by itself is not bad, because I have been the victim of a res judicata judgment in the CCJ when I represented the government of Belize. I didn't expect it, but it came, and that's fine. But to add frivolous, vexatious, and abuse of the process of the court, I think that's what you said.
Yeah.
These are very telling words, and I think to the lay persons listening, they basically said, to use layman's language, a complete waste of the court's time, resources, and energy to have to sit there and listen to the arguments and write a judgment. And I think the only reason why there were 3 judgments delivered, my experience tells me, was that the court wanted to send a message. If there were just one judgment, because the three were substantially on the same dance floor, was to send a message. And I think it's a significant message. But then to go back to the first question you asked, my dear friend, in the light of that language, I was rather surprised a stay was granted. In fact, I mean, you don't grant a stay to an appeal you have said is frivolous, vexatious, and an abuse of the res judicata. Because one of the fundamental fences you're going to have to jump to get leave is to show that your appeal is not frivolous, vexatious, and abuse of the process of the court, and it's one that has merit that the CCJ can chew on. So I found the stay a little surprising. In fact, when Mendez and I spoke, I asked him, well, what is that stay about? He said, well, he don't know, and he asked, and he didn't quite get an answer, and so on.
Right.
But I think for the people of Guyana, frivolous, vexation, and abuse of the process of the court is that the applicant or the appellant and those that are behind her and others, the court is sending out a very strong message. Stop wasting the time.
Right. Thank you, Counsel. To you both, Sanjeev, you first. From a layman's perspective, I'm sorry to be harping on this topic, but from a layman's perspective, the lower court basically dismissed everything and said, look, it's something that was dealt with already. We're not going to give a... You go to an appeal court, the appeal court said the same, pretty much the same. A stay has been granted at the appeal court. Does it mean that the lower court's decision still holds? I mean, how do we translate these things?
The funny thing, Yog, is this. In the effect of what the order is, if you want to give effect to it, and you will have to stay in these circumstances, perhaps the only interpretation is that you're saying is it's as if the appeal had not been heard. You're suspending everything you do as if you haven't given a decision.
Right.
The funny thing about that, Yog, would be if that were true, and I'm not saying it is true in this case, but if that were true, then the decision of the Chief Justice, which is contrary to a stay in any form or fashion, is the judgment that you fall back towards.
Right.
You know, and Yog, this is one of the things that I, from been hearing from people, and that people are texting and messaging and phoning me about all the time. The thing is, everybody in this country know the exact number in every district what happened. They know what the final results should be. And anything that takes you away from that or divorces that from coming into being would not be countenanced by a court. And I know that we have different levels of mistrust in our judicial system. And there are persons who have grave criticisms for the system. But we have to look at the fact that you have asked this question in 3 courts and more: the High Court, the Full Court, and the Court of Appeal. You've asked it in 2 courts in David, the Court of Appeal and the Caribbean Court of Justice. You've asked that same question in 2 more courts. So 7 times this has been done. And it must be obvious to even the blind must be able to see at this stage that what you are trying to achieve and the rights that you're claiming has been breached, violated, whatever you want to say, that the judges are not in agreement with what you're saying. So at some stage, everybody has said 7 times, Yog, all that you say, we hear you. We understand what you're saying, but you have to file an elections petition. Bring your evidence. You will get redress once you prove your case. You will get your justice. Mm-hmm. But it's this obstinate thing that we don't want to do that. We want to do it this way because it suits us this way.
All right.
So maybe.
But Sanjay, could I ask you a question? if you were in their shoes and you know full well that these allegations were homebrewed stuff, right? And you don't have the evidence or the witnesses to back it up because the observers were there, Guyanese people on both sides of the fence were there, saw what happened. I mean, would you jump to file an election petition?
There is no way that the election petition, I've said it
It's
before,
going to be filed.
nobody in the history of the world has ever filed an elections petition to a court to be declared the loser of an election before. Nobody has ever done that. And
That's what I'm saying.
So it's not going to be done. But what I don't understand, I remember, Senior, I remember there was Observer. They was observing the Privy Council, the radio license, I believe it was. And Yog Senior was representing a government that did not give a radio license to Observer, and the court told him, well, you should come back and let us know what's going on. And what Senior said is, have you ever been made to be something you want to be? You know? Lawyers have got to have, when you realize that everything is laid bare and you realize that the situation is what it is, lawyers have a duty and an obligation to say, you know what? We can't advance the argument any further. And in this case, the argument cannot be advanced any further. And all that is happening by the actions of the lawyers here is to incite people, is to give people false hope. You have to say to them, well, look, this can't go on. What has to happen is we have to take the petition.
Right.
And then we're going to find out what evidence existed all along.
So let me say this, Senior, both you and Sanjeev, you guys would have been so busy, and I'm sure you forgot this, but I didn't. The last time the four of us were in room 592, I asked the question, is there any wriggle room? Would there be any wriggle room? And the answer emphatically was no. And I guess the court today showed that there was no wriggle room. I know you lawyers would have told me that, right? But the court today showed that there was no wriggle room. But sir, Senior, there now seems to be the intent to wriggle on the procedure, to then go to the court, copy, paste the same thing, and go on to another person. Now, my question, all of that aside, my question is as follows. 3 individual matters have been filed against the chairman of the Elections Commission. Senior, to you and Sanjeev. Personal matters being filed like that, does it tie her hands from doing her constitutionally bound duty as she ought to be doing?
Well, I think first of all, let me just make the general comment that these criminal complaints against the chairman of GCOM is a naked partisan abuse of the process of the court. I mean, I've never seen anything like it. She's being charged criminally by a politically inspired criminal complaint to do what the CCJ said she has the authority to do, and which now 3 judges of the Guyanese Court of Appeal has confirmed that she's right. I heard one of the justices say today that she's absolutely right. That's not a matter for GCOM, but Lowenfield is meaning the determination of the disputes, and she and GCOM have the right to instruct the chief elections officer, who is a servant, well, subordinate to the GCOM and subject to the directions of the thing. So the 3 judgments today has shredded and burnt and destroyed the integrity, the credibility, the obvious naked politics of these cases. I've never seen a chairman ever charged, right? I've never seen a chairman of any commissioner discharged criminally, either by private criminal complaint, which is funded by political persons on one side, or by anybody else, for simply doing what the court says she has the authority to do. I mean, it's mind-boggling. And one other point though, I think the reason why the courts have probably been a little more patient than you would have preferred. This is such a highly contentious matter. I think the court says, look, this is going on perhaps since the incredible story of the majority vote of 34. The recent judgment of the CCJ being the second. This is now going to be the third. I think the courts are very sensitive to the political consequences of this, and they would allow as much rope as is possible. But I think the wriggling is slowly coming to an end, unless there's going to be an unconstitutional or military or some other illegal form of subverting the democratic process in Guyana. I can't see it going anywhere else.
Right. Sanjeev, sir, today appeal, could you share a little bit of the cross appeal of the Attorney General? Because I believe the cross appeal was as well dismissed.
Well, Yog, let me try.
Sorry, Sanjay, before you go on, could you tell me, I'm curious, I'm really curious, what was that cross appeal about?
I want to be very careful about it. Now, there were 27 grounds of appeal filed by the appellant. There were 11 filed in the cross appeal. By my reading, and I'm being charitable as I can be, but I will say to you, Yog, that the cross appeal was identical in many regards to the grounds that were contained in the substantive appeal. Essentially, the court was wrong with jurisdiction. The court had to direct GCOM to accept Mr. Lowenfield's report. That Order 60 had been declared invalid by the Caribbean Court of Justice, that the court couldn't do anything in relation to Order 60. These were identical issues. The other cross appeal, which was the cross appeal filed by Senior Counsel Douglas Mendez, was that the jurisdiction of the court that was narrower than the court had, because what the court did, the court said indeed that it was a very narrow jurisdiction, but in the next paragraph, the court said that it was a matter to be considered as it arose. And in those proceedings, I think it was unanimous by all three judges that they felt that the narrow approach, which is Hollandar's approach, in fact, the narrow approach was the preferred approach, and that was the only thing for which the court would have had jurisdiction. But the cross appeal was dismissed. In fact, Yog, I can tell you that other than Senior Counsel Mendez, I think it is fairly safe to say that the other respondents ignored the cross appeal in their submissions. Because having dealt with the issues raised in the substantive appeal as it existed, then there was essentially, you would have dealt with it. The submissions, of course, covered the issues, but I don't think anybody, at least in their speaking time, nobody took too much effort. Everybody in their written submissions did, and by their speaking, covered the issues. I mean, all that it will do, Yog, as Senior Counsel here will tell you, is it means the state will have to pay cost because they are now a losing appellant. Essentially, they've injected themselves into it, and they will now have to pay costs to all the respondents who have addressed all that has gone on. So that's all they've done. All they've managed to do is put a burden on the coffers of the taxpayers. That's all that has managed to happen.
I am very curious. That's why I asked about the cross appeal. What standing does the Attorney General have? This is a matter between GCOM, the supervisor of elections, and the political parties that have contested the election. Are you also a lawyer, Yoga? I think you are, right?
Yeah. He has a law degree, senior.
Okay, all right. Because the reason why I ask is that I see the Attorney General in these matters, he's making submissions and so on. Nobody has really taken the point. In the OECS jurisdiction, and the law could not be that dissimilar in Guyana.
Correct.
The only time an Attorney General is entitled to intervene in matters of this kind is after an election petition has been filed, and the Constitution gives the Attorney General a constitutional role to intervene to protect not a political party of one kind or the other, but the public interest.
Mm-hmm.
And yeah, for the public interest, to go back in time, when I did one of the first sets of election petitions in 1994-97 for the then Antigua-Barbuda Labour Party, I represented the politicians. And my dear friend of blessed memory, Mr. Carl Hudson Phillips, appeared on behalf of the Attorney General. And he's a man that is steeped in the law, and he said that his role is not to be part of a conflict, but to be protective of the public interest. So I am wondering aloud, because the deep-rooted involvement of the Attorney General in these matters is a matter that would have been of concern to me if I were Guyanese and trying to figure out, well, right, if you're the chief elections officer, chief legal officer, advisor to the government, and it's your duty to represent the public interest of St. Lucia, what are you doing in a political fight? What are you doing? No election petitions have been filed. Then I think under our jurisdiction, he would be entitled to come and say, well, look, as the Attorney General, my lady or my lord, I'm intervening to protect the public interest.
Right. Well, so Senior, let me just say this.
Let me say,
the gentleman did say, whether it was Saturday or the day of the management hearing, he did say, I am the upholder of the Constitution, and I'm here to uphold the Constitution and to look after public interest. So it seems like APNO EFC's interest coincides and is wholly and solely public interest, and he's there to uphold the Constitution on that.
Well, let me tell you why. I know Sanjay wants to jump in, but let me tell you why I find that even more troubling. Because the role of the guardian of the public interest would have been to assist the court in arriving at the right conclusion by putting two sides to her and not taking a singular approach, and certainly not a cross appeal on a matter which clearly does not raise public interest issues, because the court has described them as frivolous, vexatious, abuse of the process of the court, and res judicata.
Right.
I'm not personally attacking the Attorney General. He probably doesn't appreciate the situation. Probably doesn't. But I wondered aloud, because I keep seeing him in the Zoom meetings, and I wondered, well, maybe Sanjay could give us a more in-depth analysis of his role.
When Sanjeev done, I might want to come in here too, because this might give you some context here as well. Go ahead, Sanjeev.
I will tell you this, Senior, not to tell tales out of school, but since the no confidence motion was filed and the Attorney General filed one of those proceedings as it related to the majority vote was 33, was 34 and not 33. He filed those proceedings, and he was part of the RAM case all the way to the Caribbean Court of Justice. He took a side, and we complained about it. We said this was not the way that it should have happened. Then we had Yulita Moore. We had Ulita Moore, we had David, and we had this. He was named as a respondent in all three of these proceedings. And he came against the respondents, all the other respondents. He took the side of the applicants and the appellants in these proceedings. And that has received comment of the court to the point where, in this case, in the court below, the Chief Justice granted a cost order because we had some time within which to put in our applications for cost. And after the submissions had been made, the Chief Justice is of the opinion that the applicant in this particular proceeding, Ms. Jones, and the arguments advanced by the Attorney General, who she said was in support of the applicant's submissions, they were losers, and that costs had to be paid by the applicant and the Attorney General to the winning side. Now, that to most Guyanese citizens, because costs is only recently come back into our jurisprudence in a meaningful way since about 2016. They don't realize, as Senior would appreciate, that when a cost order is made against you as a litigant and you were not the instigator, you are not the applicant coming into the proceedings, and all the respondents get their costs, but you have to pay costs with the applicant. It is indicative that you and the applicant argued the same points and that you supported the applicant, because the way cost goes is the rule is that the loser pays the winner. But it really is, in the end, when it's done an assessment, it almost goes point for point. As a general rule, the winner recovers. But they also look at what you argued. And if all your arguments or half your arguments, the court takes those things into consideration. But it is very unusual. This is like plaintiff and defendant in the old system.
Well, no, Sanjay, it's worse than that. It's worse than that. I didn't realize that had happened. Sorry to jump in. I'm feeling Guyanese now.
Go right ahead, Senior.
In public interest litigation like this, right? The courts are very reluctant to issue an order of cost. In fact, there are judicial statements that court ought not to be awarded in these matters, whether the election petition, judicial review, constitutional matters, unless the court is satisfied it was either frivolous, vexatious, and abuse of the process of the court and res judicata and so on. And so the judge ordered the cost in this case, which reflects the judicial temperament down in the smaller islands with no oil in the OACS, if I may put it that way. Mm-hmm. So you are saying, Sanjay, that the Attorney General interviewed as the respondent filed submissions wholly in support of the submissions that the court found to be res judicata, frivolous, vexatious, and abuse of the process of the court? That's what you're saying?
Mm-hmm. Well, what happened is his arguments were entirely in support of the applicant. So he filed an answer, an affidavit. He did all of that, and it was determined that what he was doing, essentially what it turned out to be, is the applicant and the Attorney General will bring in proceedings against all the political parties. That's essentially what it came down to. Now, we even have to look at things the way they are. Mr. Harmon, Senior, who is one of the
campaign manager. He's a campaign manager.
Yeah, but he's a ranking member in the coalition, the APNU AFC coalition. After the decision was given by the Chief Justice, he made several public statements. And in his very first public statement, he said that we don't agree with it, essentially, and we will appeal the decision to the Court of Appeal. So onward we go to the Court of Appeal. The strange thing about it is this: APNU AFC were not a party to the proceedings. The applicant was a party, GCOM chairman and GCOM was a party, the Attorney General was a party, and all the other political parties in Guyana, except APNU AFC, asked to intervene. They did not seek to intervene in the proceedings. What happened? They chose not to be involved. But he said publicly in his statement, he said it orally, and it was a written statement released where he said, we will appeal onwards. Clearly, that was indicative that Ms. Jones was the we, because there was no other we. And so he appealed it onwards. Then we have the submissions of the Attorney General was mirroring that of the applicant. Then we had the appeal. The cross appeal is identical and mirror in the appeal filed by the applicant.
Right.
And the arguments of the Attorney General and the applicant in the Court of Appeal were identical. The whole nation saw that too. You know? And we don't know, Senior, why it is that the Attorney General, who ought to be the one who says to the court, Judge, the positions are A and B for you to come to your thing. This is the law. This is the law. And it is my view that this is where we can end up. And it is my view that this is where we should end up. That's the sort of thing that should really be the engagement. That's the expected engagement.
Yeah.
But that's not what we had here in Guyana. That's as far from the truth of what actually took place here.
So, Leonard, just a clarification before you go, Len, please. So Sanjeev and Mr. Astaphan, going back to what you said, Senior, the Attorney General has been placed in a most uncomfortable spot then, because he has presented a matter, ladies and gentlemen, viewers and listeners. Our Attorney General would have taken a position of arguing a matter that was res judicata. He's supposed to be the fount. He's supposed to be the pinnacle of all things legal in Guyana, the keeper of our constitution, the keeper of our laws. But in him taking a political stance, he would have basically been gobsmacked, slapped silly. Those are my words, not necessarily Senior's words, in court today by being told all of these things are res judicata and your appeal is dismissed. However, my question is as follows, gentlemen. Mr. Attorney General is a public servant. He spends from the public purse. When he engages in such action, is there any power, Sanjeev, to the people that he ought to be representing, the people of Guyana, that can stop an Attorney General from employing a battery of lawyers to spend the people's money in representing a case that may not be of the people's interest, sir?
Yog, the truth is, yes. The charge would be misconduct in public office. And we know in Guyana, misconduct in public office has become the whipping boy to protect the democracy. But the truth about it is this, Yog. If a public official is exceeding what he is entitled to do, and if a public official is engaged in a manner where he should not be, then, to be honest, he is not doing the job that he should do, and that would be the recourse. In these current situations that we have unfolding, and because they are so fast, if you look at what has happened at 8 o'clock in the morning to 8 o'clock in the night, the news cycle has covered so many things, so many actions by so many people, public officials and otherwise, who are saying this, doing that. And the constant tit for tat back and forth, I don't know how practical it would be to address it. It might not be very practical. But to answer your question, yes, you're not without recourse.
Okay, thank you.
Sanjay, I thought you were going to say that the recount showed the people already decided what should happen to him. I thought that's what you were. I thought that's what you were going to say.
I was trying to avoid that.
Anyway, let me leave that for now. I'm not Guyanese. I'm not getting further involved into the and not no further trespasses from me on that one. I was just curious. Okay.
Leonard.
Yes, thank you very much. And that was a good point that Sanjeev would have raised with regards to Mr. Harmon's statement, because I want to bring you back to that. A lot of people were a little alarmed, especially with one of his paragraphs here. The Guyanese people will certainly examine in a more meticulous way the manner in which their justice system functions. This would have come in out of the same people that went to the court and probably are likely to go to the Caribbean Court of Justice. How worried should the people of Guyana be with probably some interference into the way that the court works? Sanjeev,
Who was that for?
Sanjeev, both of you guys.
You'll take it, Tony, or I could go ahead.
No, I thought that was directly to you. You go ahead.
You see, I'll tell you this, Leonard. This is the problem that we have, right? My personal view is what is going on is this. There is the realities of what the law says and how public officials should act and what they should do. And then there is a vicious propaganda machinery in existence that takes the position of whatever the government or the de facto government wishes to do, whatever they wish to do, they create their own narrative, or they attempt to create their own narrative to justify. So the sad reality of it, Leonard, would be this. It is not difficult to ascertain what should happen and what should not happen. It is not difficult to pinpoint what the public officers should do and should not do. What is happening is this, and it is a consistent thing that is going on all the time, is that they are trying at various levels to create a narrative that is in fact false, that does not represent the law, and does not represent the duties of these public officials. Let me just give you two quick examples and you'll see what I mean. Nobody seriously thought that 33 was not a majority of 65. No sane human being could have thought that. But what happened was there was a deliberate rollout by persons of various standing in the community and in political circles to say that this was something that had to be explored. Utter BS. There's no other description for it. But that's what happened. And then there was an argument that was going on and going around in circles about whether 33 or 34 is the majority. Utterly preposterous. Then we have this situation here where people are saying that Lowenfield, remember all the video clips that were circulating, that Lowenfield said, I act on the instructions of the commission only. I am ready to do whatever is necessary. Once the commission instruct me, I am going to go and do what they want. Remember, we had all of that too. And what happens with it? All that happens and all that comes out of it, Leonard, is that you have persons go on social media, go on the Chronicle, go on the radio, state-owned apparatus, and they say these are the views, and it's totally false. It's totally false. He doesn't have that right to do as he pleases. The courts have said so. Every sane person who reads the statute, you don't need to be a lawyer. It's very clear what is written there. This is not rocket science. But what we are doing is this. Whatever it is the government wishes to do, They send their keyboard warriors and they send their persons out into the public domain to promote that for 2 days, and then that's what that, or a day, whatever it is, and then they do it, and then it becomes an argument as to whether it's rational or not to do, when it's totally preposterous. So we have public officials that are abdicating their responsibilities of independence and becoming politicians. We have the umpires playing the game. That's what's happening.
Well said, sir. The umpires playing the game indeed.
You know, there's a story that rest his soul, Sir Fenton used to like to refer to. He said there were 2 boxes in the ring, and he would always make reference to this when your own witness is selling your case down the river. And he would always say there are 2 boxes in the ring, and one boxer is being beaten badly, and the other boxer is obviously winning. And he goes to his corner, and his manager and his cut man in his corner says, "You're doing so great. Everything's going fine. The other man's not laying a hand on you." And he says the boxer response is, "Well, one of you better watch the referee, because somebody's beating the bejesus out of me in that ring."
That's right. That's right. Well said. And just before we continue, let me pause to remind everyone, you can get us on Facebook, you can get us on our temporary YouTube channel, you can get us if you go to the Kaitor News website page, ladies and gentlemen. And to also remind you that following the Court of Appeals decision today, we have already received words from a number of international agencies. The Assistant Secretary of State in the US, Michael Kozak, would have mentioned sanctions earlier. And ladies and gentlemen, as of this evening, Luis Almagro, the Secretary General of the OAS, has said the following: "The right of appeal is a privilege that should not be abused, especially in deferring the will of the people. Guyana has spoken. GCOM must declare results based on the recount." Senior, indeed today, all 3 judges pointed to the recount, that the results of the recount was the necessary basis upon which the elections must be declared, and 2, that the CEO is an employee of GCOM, is not a constitutional officer. And so, in other words, he ought not to be going on a frolic of his own. Sir, is there any likelihood, I know there is because you can't stop humans, given the stern words issued in today's hearing, is there any way that our Chief Elections Officer could be advised by his intellectual masters to still abuse the recount numbers in the way he attempted to do last time around?
Well, I don't think they should be only concerned about the statements that are being made in the court today and by the Chief Justice. I think they also need to be extremely concerned about the statements coming from the regional community and the international community. I mean, the language being used is indicating that patience is running out. And the reason for it, and I think I would like to explain the reason to the Guyanese people, is that observers were here for the election. The observers said the election, the voting process, the actual dropping of the ballot in the box was in keeping with this and keeping with that. The problem they had was the count. And as a result of which, I think Order 60 was made to facilitate the count, which was, I wouldn't say supervised, but under the eyes of CARICOM observers who would come. And the conduct of the parties involved, including the party in government, is causing the international and regional community significant concern. And they have, I think they have well past reaching the reason, the decision that there is some sort of slow progress replacement of the legitimate government taking place. That's why I was very interested to get confirmation today from the Court of Appeals decision that the Order 60 is part of the election law. GCOM can give instructions and Lowenfield must comply with the directions from GCOM. He cannot direct them, they must direct him. And I think that's a significant fact because he was being told, and I heard it from the highest quarters as well, saying that GCOM cannot tell him what to do. He can tell GCOM. But I found that an absolutely insane position to have. And I'm not aware that any draftsman could have lost his head in drafting the laws for election.
Counsel, just push it a little bit further. If Lowenfield decides to now still play around with those numbers, will he be in breach, in contempt of a court's clear position now?
Very good.
I think that's a very good question. I think he would be, because the language of the court that I summarized from the little that I heard was that he must comply with directions from GCOM. I get a distinct impression, looking from afar, that Lowenfield feels that he's politically protected and that he can continue to defy the inevitable and continue to defy GCOM and continue to defy the regional and international community. And that's very troubling. That is very, very troubling. And it's part of the problem lies in the question I think you or your head guy there mentioned about the possibility of interference with the court. I leave that response to Sanjay to deal with, but it's coming dangerously close.
Yep.
That you have openly defied the decisions of the Court of Appeal by, quote unquote, utilizing the very processes of the Court of Appeal and the High Court, the Court of Appeal, and the CCJ. But I think with the findings of res judicata, abuse, frivolous, vexatious, and abuse of the process of the court, the wriggling room has significantly narrowed. The question is, what happens next?
Right.
There's no house to dissolve, so you can't dissolve the house and go to another election.
Correct. So Sanjeev, back to you on this question. You know the players well, and it is widely felt that Mr. Lowenfield's political masters are, of course, advising him. Sanjeev, two questions for you on that front. One is the same question Senior deliberated on with regards to Lowenfield's breach. What breach would he be committing if he choose to continue to ignore the court's rulings? The reason I ask this, Sanjeev, is any of the court's ruling directed to Lowenfield? Could he say, I was not a party to that, or that decision was directed to me in my person? Is there anything he could come? And the second one, Sanjeev, Mr. Lowenfield, sir, he is costing the taxpayers $1.7 million a month, minimum. His deputy is costing the taxpayers approximately $900,000 a month minimum. All of these months that these people have not been doing what they were supposed to do as a taxpayer, is there anything that I could do to recover my money?
Well, the recovery again is about duties not being performed, breach of obligations to the public, not doing your job. Those are again all of the misconduct, misfeasance line of offenses, and those are where the recoveries would have to come. But to deal with Mr. Lowenfield and Mr. Lowenfield's thing, if you look at the keyboard warriors for the coalition, They're all giving glowing praise to Mr. Lowenfield. He is considered a hero, perhaps, to them. What they're saying to him is, we've got your back, and similar things that's going on. But let me tell you, just so that senior, I hadn't mentioned this before, but this is the strangest truth of it all. Mr. Lowenfield, when he was private criminal charges were filed against him, that he is refusing to do the job that he must do, and that he has done things which are wrong. And those charges have been filed, and I think it's very clear to see how they will succeed, because the recount exposed all of the shortcomings of Mr. Mingo's evidence, Mr. Mingo's numbers. But guess what? They couldn't get Mr. Lowenfield to serve him. So the magistrate ordered that the police are to find Mr. Lowenfield and serve him with the summons so that he comes to court. Again, that was not getting done. The chicanery that was required, the chicanery that was displayed is unbelievable. The lengths to which the attorney involved and the client had to go to secure service for all of this happened. Now, guess what? Anybody who would pay any attention to the footage that you see almost daily on the news, the various news agencies and services here, Mr. Lowenfield has police details. He is protected by the Guyana police force, who are looking for him and alleging that they can't find him. Now, if that is not preposterous, I don't know what is. He alleged that he was threatened, and I sincerely hope that no one is that foolish in this country to threaten to harm public officials, whatever your views are of them. But he said that he felt threatened and he had received threats. He has an entourage of 4 vehicles with him, and they are members of the police force attached. They are member of the city constabulary attached. These are all branches of the Guyana police force. How is it the police force are looking for him and protecting him at the same time and not finding him? I can't think of any logical, reasonable, or fair answer to that question. Whether Mr. Lowenfield believes that he is a law unto himself, I believe has been clearly set about by every court in this land, the High Court, the Court of Appeal, and the Caribbean Court of Justice. He is not a law unto himself, and he must follow what is being said. Now, they will argue about whether it forms part of the order of court or whether it was just in the reasoning of the decision. But he would be well advised that everything that is contained in a decision is binding. He cannot claim that it wasn't binding because he was a party to the proceedings. He did not offer any arguments in the Caribbean Court of Justice, and in fact, he didn't offer any arguments in the proceedings just concluded in the Court of Appeal. But he is a party to the proceedings. The orders that are made in those proceedings bind him. The reasoning, the rationale, and even if we want to term it as lawyers would do, obiter dicta, there is good authority that what is contained in the obiter dicta is similarly binding on the parties to the proceeding. Now, Lowenfield has been unbelievably stubborn in doing what he wants. And he has taken it upon himself to say that he could determine validity. But we get back to what Leonard was talking about a little earlier. There is no way for him to determine validity. No law gives him any, not even a shadow of authority. But the government has used the state media, and they have funded it all through social media, all through the Chronicle newspapers and the radio and the television, to say only valid votes, and Lowenfield is the man to determine valid votes. And that now their supporters say, well, that's what must happen. He must do it. But who made him judge, jury, and executioner. He is a civil servant. He has
Exactly.
no protected rights, and he has no mechanism to do this validity. And the CCJ is clear. The validity has been decided already by GCOM. His goddamn job is to add up the numbers and say how many seats. That's it. He is essentially, at this stage, a bean counter. And that's what he should do. But you see, he takes it upon himself to elevate him to what he wants to be. And again, the coalition and their machinery is promoting that that is so. When there is no shred, there is no statute, there is no guide, regulation, procedure, practice, nothing that gives the CEO this authority.
But Sanjay is more than that. They're the decisions of the court that says he has no authority. I want to respond to a question Joe asked though, about enforcing the order that was made by the Chief Justice against him. The fact that he's not a party in the Messinga Jones matter, I don't see his name there. Is he?
Well, he is a party because the appeal was filed and he's the respondent. His lawyer appeared in court and said he wished to take no further part in the proceedings. I also noticed that the order of court itself does not mention it, but there is no way for him to take his name out. The applicant had to have taken his name out.
So he would be bound by any order made by the court.
Of course, he is bound by the order.
Yeah, I think that's what Joe wanted to know, whether the order could be enforced against him. And I think that the order that he must comply with the directions of GCOM is an enforceable obligation that could be enforced through contempt and other proceedings.
Senior, just one moment. He is listed. I've just looked at my copy.
He is number 3.
Number 3.
Yeah. I just wanted to confirm that was him.
Yes, that's it.
And
Thank you.
And Yogi, if I may, Justice Rishi Prasad today significantly, I'm not sure if you guys would have found it significant, but I did, that he would have been taking some pot shots, if you will, at the decision in the majority decision case with Yolita Moore. Is this something that we would normally see in cases that a judge would come out and say openly, especially in the Guyana scenario, in the regional scenario, about his colleague judges in their decisions?
Well, just before you answer, Sanjeev, what I had a smiling moment about, he had a bragging moment, didn't he? The lone wolf.
No.
Yes.
But it was a remarkable thing. But Leonard, just before Senior and Sanjeev answers it, I dare say, coming out of Mr. Prasad, one could have sensed a degree of frustration. We have heard this, we have dealt with it, it has gone to the highest court. I've been the lone wolf in my decision. The court of the CCJ took my side on this thing. But Sanjeev, over to you to probably put it in better terms.
I will just give you the groundwork. I'm sure Senior will be better at explaining this to you. But I will tell you what happened. As part of my submissions in the court on Saturday as well, I made a point of highlighting that Justice Prasad, in his minority judgments, had been holding very consistently that jurisdiction did not apply except for a specific purpose. And that was the Hollander line of purpose, the trilogy of Norton, Hollander, and Hamilton, and for no other reason. And what Justice Prasad did, he recognized as well that basically what he did in tracing this whole jurisdiction in the Court of Appeal, he basically said that I have always held this view, that it is not, the court has a very limited jurisdiction carved out by the acts of the public official, and that it can't be a member of the commission and any act of the commission, and it can't do anything to do with the validity of votes or the election. It has to be totally outside of that. So I think in the context of jurisdiction, it was an important statement that he perhaps blow his own horn a bit, because for future reference, what you will see people saying is that when the PPP come to the court about jurisdiction, the court say they have jurisdiction. And when APNU goes to the court about jurisdiction, the court say they don't. The reason for that, Yog, it's nothing to do with favoritism. It is, and I dare say, at the risk of sounding a little arrogant, that we have understood what are the limits of the jurisdiction, and we have been obeying those rules, filing within what we have jurisdiction to do. And we have not been bringing cases outside of what we thought jurisdiction is, while the other side has been doing that. They have been taking too wide an approach. So the jurisdiction is very limited. It only applies to the public official who is not on the commission, and it cannot relate to the validity of the elections, or anything to do with the count, etc. So it's a very, very narrow thing. And that's why in Hollander, what they said is the returning officer was obliged to show the statement of polls while he was doing his tabulation. He was using a spreadsheet. The judge said, no, you can't do that. The law, the statute says exactly statement of polls, and that's the document you must use. So there's a distinction, but I believe that Justice Prasad, I mean, he might have taken a swing at his colleagues to some extent, but I believe what he was trying to say is, look, these are the reasons why before I thought there was no jurisdiction, before A for B. And on this particular occasion, I think we have a little sliver of jurisdiction. Remember, Hollander did not go to the Court of Appeal before. So the Hollander application didn't go to the Court of Appeal. So in those circumstances, I think he was just using the trilogy of cases that have come up recently to outline the issue. He might have used the Lone Wolf, and I'm sure that that name will stick now forever on him. But I believe that that's what he was really doing. And it was an important thing because, as Senior will say to you, it clears the position for precedent when a judge deals with what the others are saying and why we are saying what we are. But I'm sure Senior could cover that territory a lot better than I could.
Right. Gentlemen, the attorneys for the appellant, they stopped short today to say they're seeking leave to file an appeal at the CCJ. They did say they want time to consider their options. You know, in your practice, don't you prepare yourself and your client for whatever way the decision go on decision day, so that your options are well known to you and your client on the day, and you immediately make a preemptive or an announcement, here is what we're going to do? Why ask for a stay? Senior, and the second question, Senior and Sanjeev, is today there was a little bit of a display in court where one of the attorneys said, why are we discussing all of this cost? Because everybody here just latched on to this case. They were not part of the list or part of the original appeal. They latched on. Why should we consider cost for them? Is there merit in that, sir? Senior, you want to...
Yeah, well, I'm not sure what it means by the latched on, because it seems as if Messinga Jones had joined 12 respondents. And I don't know if anyone intervened rather than being joined. I don't know. The two issues I really want to respond to. The only possible way that you could prepare your client for what is an inevitable outcome is if you're being professionally honest first with yourself and then with your client. I mean, I would have been astonished that anybody could have had any question in their minds what the outcome was going to be. And I think if the Chief Justice speaks of
That's all right.
Thank you. Hi, Christoph. Yes, and if the Chief Justice spoke in the term that she did about the quality of the case and ordered costs against, I got the order of costs from
the cost of one
30
attorney, right?
yeah. And the judgment of the Court of Appeal today, I would have been in complete peace with myself by not taking up the case in the first instance before the High Court judge. But assuming there was some public interest, and there we go again, some public interest matter that required clarification or confusing, conflicting judicial cases and so on. But to put your question bluntly, I don't know what they would want to think about. I don't know what options are there when 4 judges say your case is, to use the layman's language, not what the paper is written on. But I want to go back to the lone wolf thing. I thought that was mild. I actually heard that. I did a case recently in the Eastern Caribbean Supreme Court. And this is not a criticism of the court, but to my astonishment, I lost. And it was an election matter, majority, minority, and the minority, who was the sitting president of the court, says the judgments of my learned brothers or my judicial brothers will make a mockery of the jurisdiction of the court, of the election jurisdiction of the court. So Lone Wolf,
yes,
Lone Wolf is pussycat business compared to what happens in these islands down here.
correct.
I thought he was being mild, but I think it was the consistency message with mild modifications here and there that he was trying to get at. But mockery of the election jurisdiction in court, you can't get it. You can't take it any higher than that.
Right. So, senior counsel, I could have asked this of Sanjeev, but you know he is politically biased. So I'll ask the independent gentleman in the house, sir. If you were not as independent as you are, do you see anything there that you could take this matter to the CCJ if you were on the appellant's panel?
No. In fact, I had formed a view going back a year on the majority vote of 33 and 34, and on the ability to challenge Mr. Prasad after the 21 days. I wouldn't say who, but my advice was sought and I expressed it. And I didn't get involved in it. The answer is no. And sometimes the best job a lawyer can do is not stand up in court with flowery language or brilliant writing. Is to be honest with the client and sit down with them and say, look, I know how you feel. This is a serious case. It's an important case to you personally, but I don't think you can win it. And if I come to the conclusion that I cannot win it, not may win it, or possibly win it, because once you have a possible opening, you go for it. But if the door is shut tight and the gates are over 20 feet high, you have an obligation to be honest and to tell the clients that you don't have a case. And I think one of the majority, you see, CARICOM, we are very competent people. The matter involving Prime Minister Roosevelt Skerritt in 2009, 2010 about the alleged French citizenship. One of the judges said, who ruled in our favor, this one I won you. I don't lose them too often, but this one I won. Says the time has come, and this may or may not apply to Guyana, that's what the guy needs to decide, for petitioners to stop running to the court and dragging the political baggage of the campaign, the platform, and so on into the court under the guise or disguise of an election matter. And if this continues, Parliament has to seriously consider amendments to the law to make sure that the cost provisions would prevent the politicization of the election process before the High Court. Now, it's a matter for you, Yog, and Datadin and the other patriots of Guyana, the other Guyanese people, to make a decision whether APNU is in fact doing that. It comes dangerously close to an outsider from out here, that everything is being washed through the courts under the guise of a legitimate legal fight. When the battlefield is clearly set by the CCJ, the High Court, and the Court of Appeal, which is the election jurisdiction of the court.
Thank you. Thank you for that, Senior. And Sanjeev, as we got a couple of minutes more to go, so I'm going to ask you for your closing comments, especially in terms of what's next, sir. But to keep for your comment on this as well, Sanjeev, both the lower court and the Court of Appeal determined matters were res judicata. And in that determination, it was because it was decided on by the court, the CCJ, no lesser than the CCJ. So doesn't that then make the likelihood of going back to the CCJ very slim? Over to you, sir. And with that, your closing comments as well.
And as on that, Yogi, if I may, very quickly in your closing comments, Counsel, could you say whether there's likely to be a running out of court cases on this leg of the March 2nd elections?
Running out of court cases.
Yes. Somebody said they used the term cul-de-sac a little while ago, and only Palm Court and Hampton Court is left.
Well, the thing about it, Yog, a couple things. When the attorney, Mayor Robertson, said about that costs shouldn't be awarded to the respondents because they intervened in the proceedings, that's not true. The intervention took place in the High Court. They are interested parties, they are political parties, and they're entitled to be there. And they have an interest in the proceedings. He brought the proceedings. He filed a notice of appeal where he named all these parties as respondents. So at least the cost in the Court of Appeal would be easily dealt with. It's preposterous for him to have said that. Secondly, where do we go from here? The reality is this. They had a situation where, or we have the situation whereby John Jeremy, Senior Counsel, and Mr. Williams was repeatedly saying that Order 60 is not valid, and the CCJ said so. Now, I would dearly love to see them go to the CCJ and tell them that, because they were both there when the decision was given. I want them to go to the court and say that Lowenfield has somehow or the other the ability to compel, or they're entitled to an order to compel GCOM to accept Lowenfield's report, when it was very clear from the CCJ that GCOM has to find a way to get him to obey their instructions from 16 June letter. So it is preposterous for them to do that, and they will be going back to the court that they have been skewing, misinterpreting, abusing the judgment of that court for their own purpose. I don't know how they will go to that court now and say those things about the judgment to the same judges. It will take a level of courage that perhaps I don't have. But notwithstanding that, I am not so sure that we will have an appeal to the Caribbean Court of Justice, but I have no way of knowing, and I have no influence over what happens. But I don't think so. I would hope that at this stage that the commission is to do its job, get this declaration done. Lowenfield is to realize that he is merely a bean counter. He's a civil servant. And if he wants to do what he wants to do, the commission has to remove him. And the commission must take him away, appoint a new CEO, have that person discharge the function, and let us move on. Whatever else you have to say is an election petition. And to answer you, Leonard, my understanding was this afternoon that not even Palm Court will accept the appeal.
Thank you for that, Sanjeev. And Senior, your closing comments, sir. I wish to throw one teaser at you. In Guyana, it would probably be a bouncer. I don't know if you're afraid with cricket as much, but here's what. Our AG would have gone as a political puppeteer, and my word, sir, to the OAS and misrepresented the CCJ's decision to the OAS. Sir, is there a legal recourse for Mr. Yog Mahadev?
I will tell you what. Let me end my closing remark on a different note. Sanjay mentioned the Observer case before the Privy Council, and it was hilarious. He didn't give you the full story. A few weeks before, I went to the Privy Council challenging Cable and Wireless's telecoms monopoly. And while the case was sent back, on other issues, the monopoly was held to be a prima facie contravention of the freedom of expression, which includes implicitly a right to a license to broadcast, right?
Oh, okay.
So we were very proud about that. A few weeks later, I go up now with Observer Radio, representing the government, trying to stop them from getting a license, using the clever argument of alternative revenues and so on. So when I got to the podium and so on, I don't think I got past good night, good morning, my lords, and so on. And Lord Cook it was, said, Mr. Astaphan, I said, yes, sir. Yes, my lord. You were here a few weeks ago arguing the Cable and Wireless case before their lordships. Weren't you, Mr. Astaphan? I said, yes, my lord. Well, tell me, do you plan on telling us anything different today? And I couldn't. I said, no, my lord, you know, the truth is, the Cable and Wireless case has flushed this one out. The sole issue before your lordship is remedies and so on. I said, well, don't you believe that they're entitled to a license? I said, yes, but there must be a 6 months grace. You know what Lord Cook said to me? Mr. Astaphan, your clients have had a monolithic monopoly for the last 25 years. How much more time do they really need to enjoy it? It was one of my tougher nights. But thank you very much for having me again, Yo. And Sanjay, great talking to you again.
Oh,
And your partner, Nick, your director.
You must. Thank you, Mr. Astaphan. Thank you, Mr. Sanjeev Datadin. And thank you, my co-host, Mr. Leonard Gildari. Ladies and gentlemen, it's been a pleasure to have you here. Happy Eid al-Adha for tomorrow. Stay safe. Remember, you can stay home and celebrate Eid tomorrow. It is a wonderful day that we'll be celebrating with our Muslim brothers and sisters. And so have fun tomorrow. And ladies and gentlemen, the following day is Emancipation Day. And so our prayers and thoughts will be as with our brothers and sisters as we observe emancipation as well. And let us pay heed to all the rules and regulations in the meantime about COVID-19 while we celebrate Eid and Emancipation Day. The next day is Sunday, and of course, I rather suspect if there is any updates to be brought to you, Kaito Radio will be bringing you those updates and interviews as it happens. And ladies and gentlemen, we will be seeing you in room 592 on Monday evening to tell you about it all again and to have further discussions with you. So have a great weekend. Happy Eid to one and all. Sanjeev, our regards to your wonderful family.
Good night, Leonard.
Yes, good night.
Thank you. Good night, dear listeners, and may your God be with you.
Thank you. And to my family and Leonard's family, and of course, Kevin and his couple of families he has, to all of you, ladies and gentlemen, good evening to you. Remember, do a prayer for Guyana when you can. It is still the best country in the world. Be safe. Have a great weekend. Bye-bye now.